Roberts against Gill Co Solicitors and others.
Yes,
My Lords, yesterday we looked at Section 35(2)(b), any claim involving the addition of a new party. We looked at the Law Reform Committee's report, which identified cases where a claim would fail if, during its course, the limitation period expired, but the legal owner wasn't joined in.
Yes.
And that he couldn't be joined in after the end of the limitation period. There were 5 specific cases identified in that report. The Law Reform Committee recommended the law be changed to cover those 5 cases, and it was so changed by enacting Section 35(2)(b) and the rules. The rules at the time, in fact, as made, specifically incorporated and referred to those 5 cases. You need to see that. That's at Volume 1 of the Authorities, Divider 5. And it's pages 218 and 219 in that volume. The rule amendment was made to Rule 6, misjoinder and non-joinder parties. The relevant rule starts at 5. No person shall be added or substituted as a party after the expiry of any relevant limitation period unless either the relevant period was current, date of proceedings are commenced, and it is necessary for the determination of the action that the new party should be added or substituted. And in paragraph 6 says that except for where the law of other countries applies, the addition or substitution of a new party should be treated as necessary for the purpose of paragraph 5a above, if and only if the court is satisfied that. And then it sets out A to E, the 5 categories which we saw from the Law Reform Committee's report.
So can we just see what equitable interest liable to be defeated?
Yes.
Yes.
Equitable claimant liable to be defeated because the legal claimant is not joined, is essentially
Yes.
what 6a is. And then the rest of the other 5 matching.
Right.
Now, that gave rise to a problem. The way that was done gave rise to a severe problem. And that was that a current rule at the time when these amendments were brought in was called the universal succession rule. And that stated that if one party ceases and their interest is transmitted to another party during the course of litigation, that new party can be substituted. That universal succession rule had been there for hundreds of years, been there since the 1800s, and never raised any issues of limitation. But as soon as this rule came in, it created difficulties with the universal succession rule. Difficulties were created not by the Act, but by the rule as drafted. And that's what Yorkshire Regional Health Authority in Fairclough was about.
You say that it's the rule that creates the problem, not the Act.
Yes, it is. Because if one looks at the Act, which your Lordship have in the core bundle.
Yes. Page 75, I think.
Page 75, indeed. As far as the Act is concerned, in the universal succession case, you need to either add or substitute a new party, and you need a new plaintiff inserted for the old plaintiff.
Yeah.
That would come within section 35(2)(b. And it'd be permitted because under section 35(5)(b) and 35(6)(b), you can't carry on the claim, you can't determine the original action, nor could you maintain the original action unless the new party is involved.
Yes.
So the Act wasn't the problem. It was the way the rules were designed. Because the rules stated, when they purported to apply the Act, that in Rule 6, Sub-Rule 6, additional substitution of a new party treated as necessary if and only if it comes within one of the 5
I see.
characters.
Yes,
And
yes.
it didn't. It doesn't. So that was the problem facing Lord Justice Millett in the Yorkshire RHA case against Fairclough. Now, can I just explain, before I get into Yorkshire, that that problem no longer exists on the CPR as they stand today. The CPR have been redrafted so that they don't require you to come with within one of the 5 specific cases as a matter of condition. The CPR now reproduces the statutory formula. That's Rule 19.5.3.
It just teases it out slightly, is that right?
Yes, what it does is it just follows through the statute. It doesn't impose a rule which is, in a sense, more restrictive than the statute and blocks the succession rule. It shows there that if you... 3, the additional substitution of party is necessary only if the court is satisfied with that. 19.5.3. New party substitute for party who was named in the claim form. Mistake is not a mistake. B, the claim cannot probably be carried on by or against the original party unless the new party is added or substituted as a claimant or defendant. So the universal succession rule, if I may call it that, now fits within that rule of CPR.
Yes.
Yes. But I mean, they also tease it out slightly because it would then deal separately with the case of death and bankruptcy.
Yes.
Yeah.
Death and bankruptcy was always dealt with separately. That's why I haven't taken you to that.
There was a separate rule for that.
There was a separate sub-rule for death and bankruptcy, yes. The universal succession rule, if I may call it that, the transmission from one party to another by statutory replacement as it was here, some other methods, didn't come within death and bankruptcy.
And was mistake catered for as well?
Mistake was also catered for elsewhere, yes.
So
That's always been there.
where was death and bankruptcy previously?
It was... I think it was Order 15 Rule 7. Yes, Order 15 Rule 7, which you have in your Volume 1 of the authorities.
Yes.
See, 7.1 was death or bankruptcy.
Yes.
7.2 was what I called the universal succession
Yes.
principle.
Yes.
And that applied even in a case where there had been where there was a problem about time.
It did pre-1980, yes. The problem with Rule 7 post-1980 is the apparent problem is it doesn't refer to Limitation Act 1980 or the expiry of any limitation period. Rule 6 specifically refers to that and has a very limited class.
Yeah.
So that's where the difficulty arose. So I hope it's relatively clear from that the Yorkshire Regional Health Authority case now no longer has any role to play in overcoming the problem it faced, that the universal succession rule appeared not to work.
Yes.
Could you just help me? You
Yes.
call it the universal succession rule. I understood universal succession to mean when, by operation of law, someone became entitled to the entirety of someone else's property. But the old 1572 seems to be much more widely expressed, just when the cause of action is transmitted. So Is there any learning about the universal succession rule?
My Lord, I've used that term because it's a useful label, and it was the label used by Lord Justice Millett
In the Yorkshire case, I see, thank you.
And in the Yorkshire case, both the hospital building, which the Yorkshire Regional Health Authority had commissioned and had built, and the contract between Yorkshire Regional Health Authority and Fairclough were both transmitted by statute.
Oh, and that
New
obviously was
National Health
a case of universal succession, yes.
So, my submission about Yorkshire Regional Health Authority is that insofar as it requires there to be a new cause of action in Lim 2, in 35(2)(b) of the Act, either it's wrong and there is no such requirement for a new cause of action.
Sorry, I'm missing you. 35(2)(a) refers to the cause of action.
Yes. I'm sorry, I haven't taken you specifically to Lord Justice Millett's judgment.
He said there had to be both.
Lord Justice Millett implied into 2B
sorry, yes, I follow.
an additional requirement,
Yes.
not on the face of the Act,
Yes.
that there should be a new cause of action.
Yes.
Now, I say that implication is either wrong, and it's flatly wrong, because that would prevent 2B from covering the 5 specific cases that it was actually created to cover. So either it's just flatly wrong, or, if it's correct, it assumes that in each of those 5 cases there is a new cause of action, which can only be the introduction of the legal claim, the legal cause of action by the legal owner. So on either an analysis, and there are only 2 analyses of Lord Justice Millett's judgment on that point, on either analysis, my case is established.
Sorry, the first one I've understood. The second alternative is
that if he is correct and it does include an implication for a new cause of action, then since it was only brought in with the intention of covering these 5 specific cases, that was the mischief, it must also assume, or just a minute, must assume that those 5 cases have within them a new cause of action. See?
Where does Lord Justice Millett deal with that?
I'm bringing you straight to that. Volume 5 of the authorities, and it's divided 68. Can I first deal with when he looks at the Law Reform Committee's report? Because that's on page 219, at pages B, paragraphs B down to F. B to F on page 219, he says, the legislative history of Section 35 and a consideration of the mischief with which it was intended to deal provide further support for a narrow construction of 35(2)(b).
And his narrow construction was?
The implication into Section 35(2)(b) of a further narrowing requirement that there should be a new cause of action. And he sets that out at 218 B to G. Now, I don't know which way we want to take that, but I hoped it was helpful to look at the Law Reform Committee report first, his references to that, because at 219 he refers to the Act of 1980, 3 lines down, was enacted in order to implement the recommendations of the report.
So he says that provides further support for his construction.
Yes, he does.
He doesn't say that's the reason for his construction.
Further support. Yes, but if I can just look, because it would need to be consistent in my submission with this. His construction would need to be consistent with this, otherwise it would completely frustrate the Act and he would have to rule it out, it seems, in my submission. The dichotomy, just about C, the dichotomy between amendments to existing proceedings which involve the additional substitution of new parties and those which did not, is to be found in the committee's recommendations. The committee recommended that no change was required in the rules which enabled a new cause of action to be added out of time. That was still the test has always been, does it arise out of the same or substantially the same facts? That a minor amendment needed to be made to allow a change in capacity, and here that the rule-making powers of the Supreme Court and County Court should be enlarged so as to confer power to enable parties to be added out of time in 5 specific cases, which the committee had identified, which led to the additions of paragraphs 4 to 6 of Order 15.6. The purpose of these recommendations was to allow a limited number of amendments to existing proceedings to be made after the expiry of the limitation period, which could not have been made before. They were not intended to deprive the court of any existing power to allow amendments after the expiry of the limitation period, nor were they intended to cover amendments which, though made after the expiry of the limitation period, were not statute barred. It would have been completely outside the committee's terms of reference to make any recommendation of the latter kind. So he acknowledges there that the 5 specific cases, there was a need for a change of the law, and that the Act was intended to change the law, and so were the rules.
And then the sentence at F, that's his conclusion.
In my judgment, therefore, the substitution of a new party under Order 15.7 does not involve the making of a new claim as defined in section 35.2, and it's not affected by anything in that section. Yes, and that is because he has read into that, by implication, the requirement of that there must be a new cause of action being raised at the same time. And we see that back from 218B. The paragraph starts, the second defendant's argument is simplicity itself. The trust's claim, the National Health Service Trust, that is, the claim they submit falls fairly and squarely within the second limb of section 35.2 as any claim involving the addition or substitution of a new party. The trust is a new party. It is, they submit, as simple as that.
Yeah, and then can't construe it literally.
He says it's not, however, simple as that. Close analysis shows it cannot be construed literally. That is because the remainder of section 35 assumes the 2 limbs of the section are mutually exclusive. A new claim within the first limb is subject to conditions imposed by 5A. A new claim within the second limb is subject to conditions imposed by 5B. But if section 2 is literally construed, the 2 limbs are not mutually exclusive. A claim may involve the bringing of a new cause of action by the additional substitution of a new party. This difficulty cannot be resolved by the simple process of implying words in subsection 2, so as to make the 2 limbs mutually exclusive, that is to say, by reading it as if it read. In this section, new claim means any claim involving a new cause of action, but not involving the addition or substitution of a new party. Any claim involving the addition or substitution of a new party, not involving a new cause of action, because that would leave a claim which involved the bringing of a new cause of action by the addition or substitution of a new party unprovided for. Well, that might be a result of the Act, but it doesn't. If that's an unintended result of the Act, well, then maybe that's so. The question is whether his implication can get round what he sees as the problem with the universal succession rule. He says, in my view, the antithesis is between a claim which involves the addition and substitution of a new party and one which does not. The first limb must therefore be confined to claims which involve the new cause of action, but which do not involve the additional substitution of a new party. Claims which involve the additional substitution of a new party, as well as a new cause of action, fall within the second limb. The question is whether the second limb also includes claims which involve the addition or substitution of a new party, but which do not involve a new cause of action. That's the crucial question. In my opinion, it does not. As I pointed out already, there are 2 entirely different kinds of substitution provided for by the rules, one where the party substitute has succeeded to claim or liability, or already represented the action, one where he has not. Be outside the scope of the Act to alter the law relating to the former kind of substitution, which involves no question of limitation. But in my submission, that crucial question, the question is whether the second limb also includes claims which involve the addition or substitution of a new party, but which do not involve a new cause of action. It must include those, because otherwise it doesn't cover the 5 specific cases for which the law was changed. unless it can be said that those do include a new cause of action.
Yes, I mean, you can test it by little c, which is a very simple example. The new party is the Attorney General, and the proceedings should have been brought by related proceedings in his name.
Yes.
It would seem pretty extreme to say, well, you can only do that if there's a new cause of action.
Exactly. Now, this reason was not actually, although it was the grounds for Lord Justice Millet's decision, it wasn't necessary because there was another ground, there were other grounds on which he could have come to the same decision, which he himself set out. For instance, page 219G to 220E. He decided there that the existing Order 15 Rule 7 was actually compliant with Section 35. So it was a rule of court, as referred to in Section 35, and it didn't matter that it had been brought in prior to Section 35's introduction.
Is there a short and simple answer to which bits of the remainder of Section 35 assume the two limbs of the subsection are mutually exclusive? Because I confess I don't see that at the moment.
No.
Perhaps it doesn't matter. But
Well, perhaps it doesn't matter, but to say they're mutually exclusive, they apply different tests to different heads,
yes.
but it doesn't necessarily follow that they're mutually exclusive.
Well, that's what I would have thought, yes.
For instance, since this is a permissive exception to the limitation rules, the Act could perfectly easily be construed to say, if you fall within both of them, you've got to comply with both.
Yeah.
And that would be a simple way of solving the problem, and one wouldn't have to go into this mutually exclusive question at all.
And how would that work on the facts of Yorkshire?
On the facts of Yorkshire, if you like, it's not the Act that's the problem in Yorkshire. You can always get through the Act. What you couldn't do in Yorkshire was get through the rules that had been made under the Act. And that was the only reason why the Act had to have an implication added into it.
Is that the word only, again, was the trap?
Yes. Because what you had to say, what the Act did was it actually allowed the universal succession rule to work, provided the right rules were in place. But since the right rules weren't in place, Lord Justice Millet interpreted Section 35 so it wouldn't have any application to universal succession rules at all, as is the only way around the problem that he was facing.
Can you just point to where Mr. Justice Millet uses the words universal succession? Just to be quite sure about
That's
the
at
context.
214H.
I'm very grateful.
Yes, thank you. Yes. Yes.
So it is a difficult case, Yorkshire Regional Health Authority, but in our submission, whichever way it goes, it must still be a decision in our favour, whether it's wrong or whether it's right. It must still be clear that Section 35(2)(b), the second limb, does apply to the cases that were specifically intended to be covered by the Law Reform Committee. And whether that means that's because Lord Millet got it wrong and there is no implied requirement for new cause of action, or whether it means that they have a new cause of action because they carry with them the legal cause of action, doesn't matter for my purposes. So, if I can move on from that case, what I say is that Section 35(2)(b) applies to any claim involving the addition of a new party. And we know from the Law Reform Committee report, the intention of Parliament itself, that was intended to cover cases where the only problem was that the legal claim, the party with the legal claim outstanding wasn't added prior to the limitation period having expired. So we say really the entire answer to this issue comes in the section itself and the Law Reform Committee's report.
And involving the addition of a new party is crucial to this case too, isn't it?
Exactly. It shows what's meant by involving the addition of a new party. It is bringing somebody in to get round a joinder problem.
Yeah.
And the new party here is?
The new party here is the personal representative.
So when one looks at the amendment, it doesn't introduce a new party. At the face of it, it's a change of capacity.
Yep.
Which I don't think you dispute, am I right, so far as it goes, but you say, well, you can't do that without the substitution of a new party, and I understood that to be accepted, although the point is being made against you that is just a procedural point and it doesn't actually make any alteration of substance. Now,
yes.
so far, I don't see what your answer to that is.
Well, first of all, the fact that it's merely a procedural problem is, I say, not an issue, because it was the Act assumes that the addition of the party with the legal claim, that is the trustee, the personal representative, the Attorney General, the company, or whatever, is something which is necessary to allow that claim to be determined.
Well, it doesn't expressly provide for that, though that was contemplated. But if the law were now that that's not the position, so that the action could go on without the new party being added, then, and if there's a discretion, say, then it wouldn't perhaps necessarily, quote, involve the addition of a new party.
Well,
I don't know.
I'm
not saying that's right.
It would certainly involve the addition of a new party, because it is still exactly the same sort of claim, and it involves the addition of a new party.
But the law moves on. You can see from Lord Justice Peter Gibson that the equitable assignee, for example, has his own claim. These are entirely procedural questions. And suppose the new party says, well, I don't wish to take the point. Is it really available to the other party?
Yeah.
At this point.
Throughout authority, throughout all previous authority, it has been a point that can be taken, and is taken, by the other party to the action. Or
the other party can say, I'd like, the other party can certainly say, I'd like, the present defendant could say, I'd like the new defendant joined, the legal owner joined, for my protection.
Yes.
But suppose the legal owner says, well, I waive any limitation rights I might have. Why should the first defendant be entitled to take that point if it's waived by the new party?
Because it is...
And if it's a purely procedural question and the like.
Well, can I deal then with what is meant by purely procedural? Because in my submission, it is not a weak requirement that something is purely procedural. Well, the concept of procedural, I'm sorry.
Sorry to interrupt you. I mean, there's an anterior question which is troubling me, despite the concession, and that is given the fact that other claims by other beneficiaries, assuming there are any, are excluded by the limitation anyway. Yes. I don't quite understand why the new party has to be added. I mean, I know it's accepted that it should be, but is it really?
Yes, the new party has to be added because without the new party, the action cannot be maintained to a final order. And that's, can I deal with that point? Because that point is decided by the Performing Rights Society case, the House of Lords case. And it was on the authority of Performing Rights Society that Peter Gibson, Lord Justice Peter Gibson, said what the current state of the law is. It was the most recent binding House of Lords decision upon him. And I think in my position it's important to look at the Performing Rights Society case to see what that did establish as the meaning of an effect of a procedural requirement in this context.
So I'm still far behind on this. I'm still not quite clear about who this additional party is. Here the amended particulars of claim specify him now on his own behalf and representing the estate. Mm-hmm. Now, is that the addition of a party?
No.
That's not?
No, it's not.
So that's
a change of capacity in which he sues, but he would still be suing as merely somebody with some kind of equitable, it's not an interest, but some kind of equitable right in the estate of the deceased, and the person who needs to be added in order for that claim to be maintainable is the personal representative of that estate.
Well, when you say needs to be added, I understand that's for your protection. You as defendant insist that an order which is, if pronounced against you, if one is going to be pronounced against you, has to include that party. But so far as he's concerned, he's satisfied. He's content to simply change his capacity and say, well, I'm gathering this in on behalf of the estate.
Well, look, there are a number of reasons why it may need to be included. One is as a matter of authority and invariable practice, and it is a substantial rule, although it's called a procedural too. The person with the legal entitlement needs to be party to the action.
Must be hundreds of actions by equitable assignees where the assignor is not in fact joined. Hundreds of them. Because very often he's disappeared, nobody wants him to be joined, and the action just goes on in the name of the equitable assignee, and nobody worries.
The I will come, I hope, to deal with why equitable assignments, there may be a slightly more relaxed approach to equitable assignment. The whole concept of an equitable assignment is, I have transferred my whole interest, the whole beneficial interest to you. You may pay me full value for it. It's no longer got anything to do with me, but because of some technicality, there's an outstanding legal right. And I can well see that in those sort of circumstances, the court is rather impatient sometimes with the idea that new parties need to be joined. But in fact, in Three Rivers, there was a stay so that an amendment could be brought forward to explain exactly what the various capacities were of the assignees. It had to be done, even though there was still there was a merely technical difficulty. So it's still a live rule. But with an equitable, with an unadministered estate, where you have just one beneficiary in an unadministered estate, where there are very substantial liabilities, including to the revenue, particularly the revenue. The idea in that case, in my submission, it's probably unheard of, probably never occurred that a beneficiary in that case has ever pursued an action on behalf of the estate without joining the estate. And if that did in fact happen, well, it might be very good news for the Chancery Bar, because it might open an awful lot more litigation, but it would put trust in estate litigation on a completely new footing. You just go to court, say, I'm a residual beneficiary, nothing. I may not get anything out of this estate, it may be tiny, nobody else may want to be interested in this action, it may ruin the estate, but I can start and I can pursue it almost as long as I like, to the ruin of all the other interests in the estate, very possibly at the end of the day, because I don't need to join the personal representative.
Well, you can only do it at all if there are special circumstances, don't you?
Sorry?
You can only bring this kind of action if there are special circumstances, which is a broad, to my mind, is a broad doctrine, and all of that can be kept within bounds by that very rule. So I don't see that.
Well,
And also, may I just add to that? I mean, if you're taking the point, which you obviously are, that the party needs to be added, I would have thought one needs to be quite specific as to who the other possible contenders are. You say it's an unadministered estate, so be it. We can see from the clauses in the will who the beneficiaries are, but they can't maintain separate claims against you now. I mean, the niece, the grand aunt, or whatever she is, the aunt can't do that.
You're absolutely right. As against me now, they're all statute barred.
Yeah.
Even, it seems, the revenue. You raised that yesterday. I did some short researches, and it seems to me the revenue couldn't pursue this claim because it's a shows in action rather than any actual asset. But what we're talking about here is the general rule. We're not saying it just so happens in this case there's as it's all turned out, there isn't really any difficulty. What we're talking about is the general rule. Is the general rule that the personal representatives ought to be party to any action brought by a beneficiary, ought to be joined as party to any action brought by a beneficiary in an unadministered estate? And in my submission, the general rule absolutely should be like to that effect. Otherwise, it completely shifts the power from where it is now in the personal representative's hands, for a very good reason, to an individual.
If the action is allowed, contrary to your argument, to proceed, so that it's the action of the claimant on behalf of the estate,
Yes.
what is it that he would be entitled in principle? Suppose he won. What would he in principle be entitled to recover? Would he be entitled to recover the whole of the land?
Yes, because he's representing the entire estate.
Entire estate, and then he would hold the proceeds on trust, would he, for...
Well, that's not itself entirely clear. I mean, one might say, if the money was paid over to him, one might say, well, there was necessarily a constructive trust attaching to those monies in his hands because he's received them in a particular representative capacity. I mean, he doesn't actually represent the estate in law, as it were. He's not the appointed representative. And in reality...
Though he's bringing the action on behalf of the estate,
Yes.
isn't he?
But in reality, one would thought, almost every single case to ensure that the monies were actually paid to the real personal representative.
Quite. Well, certainly the Court of Appeal seems to have thought that was what was going to happen.
Exactly. And in this case itself, just as an example, I say that would be a very good general rule, but tested even in this case, that we have an estate where it is said that one brother has already, as it were, made off with the money without paying, settling up the revenue, with the revenue. This action has been brought without any information being given to the revenue or any other beneficiary so far, and in circumstances where the current administrator was appointed in a dispute between the two brothers. He's a solicitor, now a former solicitor, who was no doubt thought by the Chancery Division to be a fit and proper person to be a representative of the estate at that point in time.
And what are his obligations?
Well, he has no obligations at all because he's not in this action.
No, but as the administrator of the estate.
He would have an obligation to gather in assets, but if he hasn't got any money out of which he can pay the cost of so doing, he's not required to do so. So,
sorry, I'm not quite sure I follow that. I mean, I'm not sure whether Lord Clark's question was directed to an assumption that the action is successful, the party having the administrator had been added. Is this the point what the administrator then does? The order is pronounced in his favour, so that the damages are paid over to him.
Well, that can only happen if he's a party.
Yes, quite, I understand that. But then is he to administer it as if this was all under the
yes.
will?
If that happens, if he's joined as a party before the final order is made and it's paid to him, then he takes that in, he's now got a fund, he administers the estate on that basis, pays out the revenue, and then divides out between the beneficiaries.
And the measure of damages, though, is the measure of damages due to the estate,
Yes.
not to the claimant.
No. That's right.
In the case of a company, where a shareholder is in a position to raise proceedings in its name,
Yes.
what happens at the
Money's
end,
paid, as I understand it, the basic rule is the money's paid to the company.
even though the company may be in the hands of the people who...
Provision will have to be made for that, but he doesn't get the money, the claimant. It's the company's money, which he's recovered for the company.
I mean, I understand that must be what he's doing it
And
for.
I have seen reference to the fact that the money is paid to the company. I'm afraid I can't put my finger on it right now, but that is what happens, as I understand it. That's spokes, I'm grateful. So, but the point I was developing was that in this particular case, seeing that Mr. Sainter appointed as a fit and proper person in a dispute between two brothers, the court didn't appoint the current claimant as the fit and proper person to administer this estate. And in fact, the current claimant petitioned your lordships from prison. He's in prison at the moment. So he might not be the right person in the eyes of the Chancery to be...
That's sort of never underestimate the value of prejudice.
That's one way to look at it, but it's...
It's a pretty fair way to look at it.
But it's true to say that once it is being said against me that you don't need a personal representative generally, and I say you do need one generally. And then it said, well, this is a good example. You don't need a personal representative, this case, you don't need a personal representative to be joined. And I say it's only a good example if one doesn't look at the entirety of the facts. If you look at the entirety of the facts, this case actually is a good example of where the personal representative needs to be joined.
But it's a very, very puzzling situation, because one would think that the claimant was, there were these various phrases, intermeddling in the estate, acting as a personal representative de son tour, and so on. And yet at the same time we know that the properly, validly appointed personal representative was a partner in the firm who were acting for him.
Yes.
And so you ask yourself, well, are these proceedings actually being conducted with, at any rate, the tacit acquiescence of the personal representative? It's a very strange situation.
But if that was so, we might have heard about it. We have mentioned before in court, on two different occasions we've been in court, mentioned each time that Mr. Sainter is a former member of that firm, is the personal representative.
It's some assignee of Mr. Sainter, isn't it? But anyway.
Is that, I do not know if a new,
Anyway, there is some suggestion in the papers of an assignment, but only to another partner.
There was some talk about it, but I don't know if it happened.
I don't think the office of personal representative is one that is freely assignable at will. I mean,
The Lordship's right. I wasn't going to take up the Lord Clerk on his terminology there. It would have required a new appointment. Of course it would have done. Substitution by the Chancellor.
Yeah.
But this point, and it's fair to say, I have to face it too, was raised by the Court of Appeal at the hearing. And it's obviously something which troubled Lady Justice Arden. She was concerned, no doubt, that in an action of this kind, the personal representatives ought to be informed, or the other beneficiaries she thought ought to be informed, and she would have reminded to stay the action so that they could be informed in case they had views. Mm-hmm. But she also thought that the personal representative ought to be a party for the protection of the estate, protection of tax liabilities too, perhaps, but for good, solid, what one might call chancery reasons. That was something she felt was entirely appropriate, as well as being the usual order, the normal order, the proper order, the required order, call it what you like. Now, I wonder if I can take you to...
Are you going to take us to performing rights?
I am. That's exactly where I was going to go. Again, with a slight warning that although I say it assists me entirely and it lays down clear principles that apply, it is still an equitable assignment case. So our cases are 40 all right. It's in fourth volume of the authorities at divider 50, I hope. Yes.
Yes.
And if I can first just show you exactly what the case was about and what had been already decided before it got to the House of Lords. Taking it swiftly, I think on page 3 of the report, actually, if you have it doesn't seem to be paginated as number 3 on my photocopy, but if you have page 3, it's the recital of the facts, comes opposite the last page with the head note on it. About halfway down, 2/3 of the way down, the appellants thereupon brought an action against the respondents for infringement of copyright, claiming an injunction and damages. The substantial questions at issue in the action were, 1, whether the appellants, having an equitable interest only in the performing rights of the songs in question, had any title to sue, either for perpetual injunction or for damages in the absence of the legal owners of the copyright. And then 2, there's this rather laughable thing about whether there are trade unions involved. Branson J. decided both questions in favour of the appellants, and he granted an injunction and assessed the damages at 40 shillings. The Court of Appeal held 1, the appellants were not a trade union, but 2, they had no title to sue in the absence of the publishers who owned the legal right, and that the action as constituted failed. And that was the decision which was upheld by the House of Lords. So here we have a case where the absence of the party with the legal interest is fatal to the action at its conclusion, at trial. Now, what that shows in my submission is that this concept of procedural means that it's a procedural defect not to have the legal owner, which you can, as a matter of procedure, you can correct by joinder. That's why it's procedural. It doesn't mean that the action's a nullity, which you couldn't correct. It means it's a procedural error which you can correct by joinder. But if you haven't joined the party by the time you reach trial, you cannot succeed. That's what Performing Rights Society establishes. That in other words, the legal owner is a necessary party for the maintenance, or call it what you like, of the action. Now,
do we find any help in the reasoning as to the point which we can carry forward to this case?
Well, what is useful is there are a number of passages. Let me see if I can just make sure I've got them all. So take you as quickly as possible. Pages 19 and 20 of Viscount Finlay, I got down first. Page 19. Top of the page, taking it 3 lines down. Except under very special circumstances, the ordinary rules should be observed, that the legal owner should be a party to the proceedings. There may possibly be cases in which a person who has made an equitable assignment might, by subsequent assignment, have transferred the legal interest in the same work to a purchaser for value without notice whose title to prevail over the merely equitable right. Such a possibility is one reason for the rule for making the legal owner a party. But whatever may be the balance of convenience, the established rules of practice should be adhered to, even in cases, of which I think the present is one, where their observance, in all probability, will serve no useful purpose.
And the law's moved on since then.
And over the page, it's dealing with top page 20, 1 line down. Some observations were made by Lord Macnaghten and William Brandt's Sons and Dunlop Rubber. Were, it is argued, inconsistent with the claim of the defendant in the present case to have the suit dismissed owing to the non-joinder of the owner of the legal estate. That was, Lord Macnaghten said no cases are no cases fail for non-joinder of actions, or some similar phrase. I do not think these observations should be read as overruling the general rule of practice as to the necessity of joining the owner of the legal estate, and the right of the defendant to have the suit dismissed if the plaintiff refuses or neglects to join him in any case not falling within the recognised exceptions to the rule. The recognised exceptions are you can get an interlocutory injunction at the outset to protect your rights, or the William Brandt's exception where the defendant themselves say they will not take the point because they have come to some other terms of settlement with the legal owner. Then there's page 30, Lord Sumner, 31. And that just says the same thing about Lord Macnaghten. Top page 31, Lord Macnaghten accepts the rule for which the respondents now contend that the assignor ought to be made a party in order that he might be bound. Points out that Brandt's case was an exception to it. Plainly, the House did not consider such to be departing from established rules of practice, nor has the case ever been so regarded. And yes. Page 29 I'm asked to show you, page 29, the top of the page, first paragraph there. The recognition of an equitable title or valid title in equity and the grant of relief to a person so entitled without joinder of the legal owner are distinct matters. The second is not necessarily involved in the first. The latter is essentially a matter of practice, and established practice ought not to be disturbed, or at any rate only very sparingly. It is certain there is no practice with regard to joinder of legal owner as generally unnecessary. As it is certain there is no practice to regard the joinder of the legal owner as generally unnecessary, it's the appellants to show that it has been the practice to dispense with it in such cases as the present. What, as I understand that refers to, is that the recognition of an equitable title or valid title in equity and the grant of relief to persons so entitled without joinder are distinct matters. The court always allowed the grant of a temporary injunction to an equitable owner in order to protect his rights, but it wouldn't give him a final injunction or damages at a trial without the joinder of the legal owner.
You get that at page 14 from Viscount Cave. He just says it's just possible that if the defendant didn't insist on the joinder, then it wouldn't defeat the thing.
Yes, and that's the William Brandt's case,
Yeah.
which was, I don't think we need to go to it, but it's a special case on its facts, and shows that the defendant, that because, in a sense, all matters that are within the court are between inter partes, and if the defendant just doesn't want to take the point at all, then why should it be taken? Why should the court intermeddle and make life more difficult? Which was, in a sense, what Lord Clark was saying about equitable assignments. It may be commonly that nobody is interested in that point being involved. But if it does come up, it has to be resolved. And in my submission, the law is as stands in Performing Rights Society. That was what has been followed in Three Rivers and held to be the binding authority on the courts today.
Is there a flavour at pages 31 and 32 of the point that the defendant oughtn't to be troubled with the character of the assignation and so on and so forth? If he's got the legal owner there, that's the secure position.
Yes.
Otherwise, he's rather having to sort of take on trust the transaction which has led to the equitable interest.
Yes.
But is there anything like that here? I mean, I think I can follow that in that kind of situation. But
there is, in relation to claims of this kind, generally, because we're talking about a general rule.
yes,
It just so happens here that the limitation period has passed. So the legal owner himself doesn't have any recourse now against my clients. He's statute barred. But that doesn't mean that the general rule, the equitable assignee can go through without having to bring before the court the legal title.
And you
is
say there's
changed.
precise analogy with derivative action?
Yes, absolutely.
All derivative actions?
All derivative actions. I don't know about trade union derivative actions, but apparently they are, even in those, it's required that the trade union should be joined. A trade union member, a member of a trade union, is not entitled himself, as it were, to officiously run a trade union, any action on behalf of the trade union. So, yes, I say all.
But can you talk in all those cases about a division between equitable and legal rights?
Well, in all those cases, there is no legal right in the person bringing the claim. The legal right is somewhere else. Whether that person has got an equitable right may be different.
Yes.
It may depend. And there's not going to be necessarily a material difference. In this case, of course, the beneficiary hasn't got any equitable right in the claim brought against the solicitors. He's only got a right because he has a right to have the administration properly administered, and he can enforce that against the personal representative. And the courts are allowed, in certain special circumstances, him to do that as representing the person. In a company derivative action, the company's shareholder himself has no equitable interest in the company's claim either. So, in my submission, therefore, there is a general, the very, if we start in, as it were, in layers, the very intent of Section 32 when created, the very purpose for creating it, was that exactly this sort of sequence, set of circumstances should be covered.
Section 35.
Section 35, I'm very grateful. Section 35. That is also the rule of law that has been applied by the House of Lords up to the Performing Rights Society and is still binding and is still applied in the Court of Appeal when it follows that. That the person with the legal owner, with the legal title, is necessary at the culmination of the action in order for that action to be resolved in the claimant's favour. So that really on any test you like, and it's also a matter of rules, and we'll come to that in a second. So on any test you like, this is a case where the joining of the legal owner is required and falls within Section 35(2)(b) as involving the addition of a party, and Section 35(5)(b) as being required for the termination of the action, and 35(6)(b) being required for...
It's curious, isn't it, that the existing defendant should be able to take a time bar point not taken by the legal owner who has no... this is the assignee's claim, which is what BCCI establishes, or at least makes clear, that it is essentially the claim of the equitable assignee. Now, he's making it on behalf of the estate, as we see in Lewin on trusts, but the legal owner is there in order to be bound, largely, or at any rate partly, for the protection of the defendant. But in limitation terms, once the equitable assignee has started his action in time, or is entitled to bring his action, then
Well, look, you're absolutely right. If the equitable assignee brings his action in time, he adds the assignor, as of right under Section 35, after the limitation period has expired. No problem at all.
So it's a little odd then to say, then one would think, though, that being the case, one would think that the question is whether the equitable assignee, the rules about whether whether it should be permissible to bring an action outside the limitation period should apply to the equitable assignee.
I'm sorry, I don't follow that. The equitable assignee cannot bring the claim outside the limitation period. If he waits
here, he seeks to bring the action outside the
yes.
The limitation period. He succeeds under little a.
But that's
even
because,
assuming you're right that
yes.
That it's
yes.
the same. That
yes,
it's
yes.
a new cause of action
It
because it all arises out of the same
facts, yes.
facts or substantially the same facts.
But because it involves a new party.
Because it involves a new party who's only joined or largely joined to protect the defendant. Somehow that means that the equitable assignee should not be allowed to proceed. Seems very strange to me. It may be the law, but it just seems very odd to me.
But coming particularly before your Lordship's house, it's difficult and stressful enough to try and work out what the law is. I agree, sometimes one loses sight while doing that, whether it is or is not sensible or understandable. But the short fact is that the estate itself never raised this claim within the limitation period. Within the limitation period, when Mr. Roberts raised the claim, my solicitors wrote to him, months within the limitation period, and said, "You've got it wrong. A solicitor owes his duty to the executors. You are owed no duty. You have suffered no recoverable loss." They made it absolutely clear. It's in the letters they're absolutely clear what the problem was. The estate did not itself bring the claim. Now, after that limitation period has expired, when the claimant had stuck to his personal claim, stuck to it, despite us pointing out that it was not a good claim, and then having let that claim go to sleep itself for the next 2 or so years, pops up and says, "Well, actually, I realise it's now hopeless." And it's part of what's being said. He obviously realises it's hopeless because otherwise he wouldn't be trying to amend. He just run his own claim. He doesn't want to. What interest has he got in recovering money for the revenue, perhaps? He pops up and says, "Well, I'm going to use the estate's claim now."
Another irony of all this is, of course, one of your defences to the underlying claim is that it is the estate's claim, and that's why the claimant can't recover any loss, assuming you were wrong on the duty of care. I do see what the duty of care point, which I quite understand is a very powerful point.
Yes.
But,
it's not the only one. We've got one of the two claims against. The claim against the first defendants is, according to them, statute barred. They plead, the only negligence they plead itself is more than 6 months, 6 years before they issue it. There are a number of defences which we haven't had to go into. If you looked at our solicitor's letter, which page after page of what the defences would be to this claim. There are a number of them.
Well, the other oddity is you say starting point is the change of capacity isn't a problem. Yes. But then you say, oh, well, it is a problem because it has to be a new party, and that party wasn't a necessary party to the original cause of action.
The change of capacity alone, it so happens that the provisions within the CPR and so on, which provide for that, are on Miss Justice Morgan decision satisfied. We challenged that. We failed on that.
That's Rule 17, isn't it?
Yes.
And that...
It is. But it is an oddity that it is not just that you have to satisfy.
Supposing that here they'd apply, you'd say there's no problem with the change of capacity as such. Now, supposing that they had therefore been allowed to amend in terms of the amended particulars of claim. And then they'd said, well, we want to add.
So which case are we talking about now? You're talking
this case.
This current case?
Yes.
Yes.
And then they said, we want to add the estate as a party.
Well, that's more or less what they've said.
Supposing they had amended first, and then they said, we want to add the estate as a party. How does 6b apply? How does that play? I mean, how does 35(6b) play?
It seems that would succeed because on the as amended there's a relation back of what I say is a new cause of action. But that new cause of action cannot succeed unless the legal owner is joined.
What is the original action then for that proposition? Is it the action as amended?
That it may be or it may not be. I'm afraid I haven't got. I can see that it's a good submission for me, from my point of view, to say, no, the original action must be the original action as originally constituted on any footing. But if it includes the backdated claim, then it's correct to say that that party could be added because it would be necessary to complete it. But to do...
I'd just like to see if you really have to go back to subsection 1, don't you, to get the thing in focus. You're assuming that what Lord Rogers suggested has happened. We've got an amended claim now with the wording that we saw in the amended form of the claim.
Yes.
And then there's a proposition, I think I'm right in understanding it, that a new party is to be added because he recognises the force of the general rule.
Yes.
But that then is treated as the new claim for the purposes of subsection 1 and subsection 2, and you find, well, yes, this is the addition of a new party.
Yes.
And that suggests that the original action for this purpose must be the amended claim.
Well, yes, Section 35(1) says that in the case of any other new claim on the same date as the original action, so that if you get your amendment in to change your capacity, as it were, that's deemed, for the purposes of the Limitation Act, to have been commenced on the same date as the original action. What it doesn't do, though, is it doesn't say it is the original action, does it? It just says it's deemed to have been commenced on the same date as the original action. If, therefore, the original action in 35(1)(b) is the same, means the same thing in 35(1)(b) as it means in 35(5)(b), then it would be the original action unamended, not as amended.
You could have many amendments to an original action within the time period. And you wouldn't say, well, none of those didn't count as the original action. You wouldn't say it has to be the original action as put in.
My Lord,
you couldn't say that.
all I'm saying is what the Act seems to say on its face. It's looking at an original action without naked of any amendments. That's what it appears to be saying. Now, if I'm wrong on that, then I accept that a new party could be added after the event. But what I say about that is that when the application, as it came before the court, in the Court of Appeal, is made, it is still an application involving the addition of a new party, because although that's not sought at that time, the case as it's going to be changed to requires that new party to be joined. So it involves the addition of a new party, albeit one can see that application is going to have to be made later on, still involving the addition of a new party. It doesn't say requiring the addition of a new party at this very moment.
The position might be different if the amendment could be made at a time when permission was not required to amend.
Yes.
Is that, I mean, I've been looking
But
at some
that would be
Scottish
within
cases.
the limitation period, though. That's only within the limitation period, yes.
I don't know what the English procedure is, but in Scotland, if it's not too technical, you can do certain things by adjustment before the stage is reached when the record is closed, and you have to do it by amendment. And I think there's some authority that you can do adjustments without permission, and therefore they get in.
It's true. It's a very narrow window. I think it's either before you serve the claim form or you serve your statement of claim. I forget where it is.
I see. So you can do that without permission.
Yes. And after that, you need permission. But as I understand it, Lord Collins was merely talking about an amendment within the limitation period, rather than an amendment that was made without permission of the court necessarily. It's the one that doesn't fall into this. Yes. But in my estimation, Lady Justice Arden's approach at the Court of Appeal stage, when she saw that a new party would be necessary was entirely right. Not to say, well, that's something which, for the benefit of the amending party, we can close our eyes to at this stage, pretend isn't going to come up, and then deal with, as it were, in half an hour's time when we've given leave to amend. It's quite right that it should be taken together there and then as a complete matter. It is the usual practice of the court never to amend, allow an amendment which itself would be demurrable. And that amendment would be demurrable because it can't itself, as presented, lead to a conclusion of a final determination of the action.
Right, I mean, why would it be demurrable in that? I mean, why would you not just say, well, it's not, you know, that, yes, of course, you're going to have to add the other party
Well,
if you want to get a final decree.
you're going to have to join somebody
Yes,
else
join,
if you
yes.
want it to go through.
Yes.
Maybe demurrable is a technical term, and as soon as I used it, I thought, well, it was never current really when I was in practice. So whether it means demurrable means you can strike it out as a matter of right, or, as in this case, you can take the point, and if no joinder is made, that point will succeed. But if the joinder is carried out, then the point fails. But either way, what is crucial is the party needs to be joined at the very moment you're applying to amend. So why give a leave to amend, which itself will require a further application for leave to amend?
But why do you say that?
As it stands, it doesn't work.
Performing Rights Society tells us it doesn't need to be, they don't need to join the party until the end of the case.
Well,
so long as it's done before the decree is granted.
yes, but it's still, if it's going to be required
Yes.
as part of the amendment, then the application involves the addition of a new party.
Then when it comes along, you look and see whether it can be done within the rules in section 35, 6b, for example.
And you look at section 36(6)b and it says the action can't be maintained until because the new party...
Unless the new party is joined.
Yeah.
Yeah.
And an action without the legal owner cannot be maintained to trial until the new party is joined. And that's what 65b means.
But supposing proceedings were to go in this way, that the amendment is permitted, and then you bring in a strikeout application. Assume that you have a basis for doing that on some ground or other. You wouldn't need the legal owner, the administrator, to be party to the strikeout proceedings, would you? That's a step which you could take, and if successful, that would mean the proceedings would be ended without the necessity of bringing the administrator in at all.
Yes, but that's a test of whether I can strike it out without a party being joined.
That's right.
But
yes.
the statutory test is whether the claimant can maintain the action.
Of course, I'm just trying to see just how far your argument goes. But it would mean that even for the purposes of a strikeout, you're entitled to say, well, we don't actually get to the strikeout stage at all because I'm going to insist that the legal owner should be there. But it does seem a strange situation.
Well, look, I dare say most cases, by the time they get to the House of Lords, have got a somewhat strange angle to them already. This case, in my experience, is a remarkably strange one, just because of the huge length of time that's gone and the fact that they've taken the wrong course and only woken up to what may be the right course at a very late stage, and none of the other beneficiaries in the estate are involved at all, taking any action, face any cost orders. It is a very odd case, there's no doubt about it. But what they're asking you to do, in my submission, is to manipulate or misconstrue even various provisions in order to save their claim. But that's not itself a sufficient basis for doing it unless there's some general, very good reason why that should happen. But the other factor is that there is currently, of course, a concluded law reform, Law Commission has got a draft bill of limitation, which is somewhat old by now, some years old, but limitation is something which which Parliament is going to be looking at sometime soon anyway. Is there anything in this case which has got such merits that the law, as I say it is, should be changed? And I can't see that there is, but that's...
Do you accept that the cause of action applying the Letang approach remains the same?
No.
You don't?
I don't. The Letang and Cooper approach was applicable in that case because there had been a car crash and there was a question of how you analyse the damages, what cause of action was applicable to the damages and therefore to limitation. Section 35, cause of action is a more elusive concept. And the reason it's particularly elusive is the one Lord Walker raised in case of name, it escapes me at the moment. I'm grateful, Henneke Major. That the only a new cause of action is permitted if it arises out of the same facts or substantially the same facts as are already in issue. But the irony about that is that if a new cause arises out of the same facts as are in issue, it's not a new cause of action on Letang and Cooper.
It'd be the same cause of action.
It would. Exactly.
Yeah.
And it's just it's unfortunately it's internal irony. Irony is not the word.
And another thing about Letang and Cooper that puzzles me and worries me, although it is so often quoted and it's now treated as gospel really, is that in a huge number of cases, it is essential for the claimant to plead a duty of care.
Yes.
And a statement of case which doesn't plead a duty of care will be defective. It's quite hard to see that that's simply a factual situation. It's another difficulty I feel about applying the Letang and Cooper mantra to this sort of situation.
Yes. And in my submission, that in this situation, the sort of factors which might be relevant are much more legal capacity, legal duty, breach of legal duty, issues as to damages, what damages are recoverable, that sort of thing. Those are all wrapped up in, it seems to me, the concept of a cause of action here. And are reflected in Lady Justice Arden's reaction to this. Well, it's simple, it's a different claim.
Section 35(5)(a), it strikes me, seems to recognise that the cause of action for the purposes of Section 35 has a wider meaning than the tag.
Yes.
Yeah.
It does look like that. But it does nevertheless suggest that if you have a new cause which arises out of the same facts as already an issue, then the limitation rule shouldn't apply, presumably because there isn't an element of prejudice there. The basic facts are already in play.
Yes.
You're not
Yes.
caught unawares and so on and so forth just because the duty is reworded or whatever else. And I'm just wondering whether that kind of point arises here. That is there anything in I rather think...
My Lord, it's a very good point. It's a point the appellants make. But it's not a sufficient point, if I may put it that way, in that just to say, well, the aim is to make sure that you're not actually bringing up anything new. There's no sort of, there's no fresh issue. And the paradigm example of that is Paragon and Thakra, because in Paragon and Thakra, the case was very fully pleaded. All the evidence was going to go in about exactly how the transaction had gone through. All the paper was going to be examined, all the various money transfers. And the only difference between as pleaded and as to be amended but refused was the allegation that not just knew or ought to have known that it was a mortgage fraud, but did know that it was a mortgage fraud. Now, that is a very, very fine line and wouldn't have required... The cross-examination, the documentation, everything would have been exactly the same. But it was such a bright line between fraud and negligence that it was held to be a new cause of action. So that saying that no fresh matters are going to arise, no new facts are going to be an issue, nothing stale is going to be revived, isn't the test, as clearly shown by Thackeray, which is such a clearly right and clearly important.
But as I understand it here, you concede that this is a case where the new action gives rise to substantially the same facts as the old action.
It arises out of substantial facts, yes.
And so that the cause of action point is entirely irrelevant, because we assume in your favour the 2A point. It's 5A which relates to causes of action, and it's common ground that this new claim arises out of substantially the same facts.
Yes.
And you have something perhaps of a windfall, as I see it. I know that you say that that's the law's the law and so on. Perhaps it is. You may well be right. But it's very, very odd, this case. One can understand that why
Yes.
one shouldn't be allowed to introduce new cases with new facts. One can well understand that's the purpose of A. And B, one can understand, if you're having a new substantive party, a new party, there again one can understand. In your case, this party is joined for your benefit and on your application, essentially. And would only be necessary, as one reads the House of Lords case we were just looking at the moment of decree, as I think my Lord Roger put it a few minutes ago. So it's odd.
It is odd.
And you could proceed on your equitable assignment and join the and subject to the discretion of the court, I think, because under one of the rules it says you must join the legal owner, doesn't it? Order Rule 19, I think it is, or 17, is it? Not actually precisely this case, but this class of case, and one which the Court of Appeal applied by analogy, I think.
Yes. And while on the rules, just briefly, CPR 64 takes you that requires the joinder of the trustees in actions relating to the administration of the estate. Now, this is, on one reading, an action in relation to the administration of the estate, as it's being proposed, because the defendant is purporting to represent the estate, and therefore it concerns the administration of that estate and the recovering into the estate of a claim that the estate's got. And Section 64 does specifically require, as a matter of rule, not a matter of practice direction, a matter of rule, that the trustees must be parties. So I'm afraid I didn't take the Court of Appeal to that rule, and it's a rule that doesn't appear actually directly in 19 where we're all looking at the time as we were flicking page to page, but it is a rule of the CPR that trustees must be.
19.53b doesn't track section 35(6)b, does it?
It very nearly, I think the answer is that it very nearly does.
Well, there's no, it refers to the claim rather than the original action.
Yeah.
Yes, the claim there must be read to be the original action, because you've got to, the rule has to marry up to the statute. You can't go wider than the statute on this. So that when you look at the claim there, you'd have to say that means the original action. And it talks about being carried on, I think, rather than being maintained. But again, there's no real, there can't be any difference between those two terms. So any slight difference in the drafting doesn't actually affect the substance of this case.
Well, 3A refers to the claim forms. You know what you're looking at there, I think. I mean, that would be the original claim form, I suppose, would it, in that rule? But the claim could include the amended claim, couldn't it? For 3B?
No, because under the Section 35, the rules can't go any wider. They can include more restrictions. They can't go any wider than is laid down in Section 35, 5 and 6. That appears from Section 35, 4. You can, so therefore, claim there must mean the original action. The claim as unamended.
Or as amended so far, perhaps.
I didn't mean to take a point. I just meant to try to illustrate the difference.
Well, I mean, that's quite, that's what I think I was trying to get at, as amended so far, is embraced within the word claim in little b.
Yes.
And the contrast with the claim form, which I assumed in A was the original one, because that's the party in whose name the claim form proceeded.
Well, but 3A assumes that party is still is still in the claim, because you're changing it there and then. So what is odd, though, is you can only substitute for a party that was named in the claim form a mistake. If you make a further mistake, you can't do it again. You only get one bite at that particular change.
Is that right? I
don't know, but that's what
that simply can't be right.
That's what it
claim
says.
form or claim form as amended from time to time.
Well, in that case, then it has the same. If it means the claim form as amended from time to time, then it takes the point away in time. Fine. My Lords, I have made all the submissions to you that I think I have to make on this particular subject of joinder, and I don't therefore want to go back over what I've said. I want to move on. This time is clearly running short. But what I do just want to refresh very quickly is my submission that while we have looked at equitable assignments, because all the cases are about equitable assignments, the commercial activity is in equitable assignments, and that what gets before the court. This case is a much stronger case than that, because it involves a claimant who has far less involvement in the action. And that's, I'm not going to refer you to commissioners for stamp duty, Queensland and Livingston at this stage. But that's clear and still binding law about just how the personal representative has the full legal and equitable ownership in the estate. Beneficiary still has a valuable asset, his right to have their estate administered. It still has substantial value, clearly full value, and can be enforced. But it's a long way away from even the equitable assignments, where by nature the courts might be taking a slightly more relaxed approach. But I say they still, any relaxed approach they take, they still have to take in the light of the binding authority of performing rights society.
His interest is diluted in two ways, and both because of the existence of creditors, and in particular, in this case, the huge unpaid debt to the Estate Duty Office, and because of the other beneficiaries interested in the estate. And so he is one of a group of beneficiaries and creditors who have a right to see the estate properly administered.
Yeah. He has the luck, of course, of having the administrator as a partner in the firm solicitors who use it.
Well, we've been there, but we're not going to get any further on that, I think.
Well, you're bringing this chapter to an end.
I'm afraid I am, yes. And I know that leaves a number of difficult points that we've gone through. But my submission is that the answer to these actually are to be found very simply within the Law Reform Committee's report and the Act itself. They are a final and complete answer. The Act for once, comes with, as it were, the instructions manual.
Yes.
Am I right in recalling that Lord Justice Diplock was part of the team which constructed the instruction manual? Was he on the Law Reform Committee? I have a feeling he was.
I looked to check, but I didn't. The bits we
Print
photocopied aren't
no,
there.
it hasn't.
It hasn't got it, no.
No, I have a slight...
No.
Maybe not, but it doesn't matter.
All I can see from the report, they took extensive assistance from Chief Master Jacob at the time.
So the expression "as necessary for the determination of the original action"
Yes.
means as necessary as a matter of law. Does it? It's not open to the claimant, for example, to say, well, I need to do this because my action is going to fail on the defendant's case at first instance, because my claim is only for reflective loss. Defendant's case is I can't succeed because my loss is really the estate's loss, and therefore I can satisfy the necessity test. I need to have this, quote, new claim, unquote, in order to advance the claim for the loss which I was asserting in the first place, which the defendant is saying I can't recover even if I'm otherwise right, because it's really the company, or in this case the estate's claim. That would be to misconstrue Section 35.
Yes, because he's got a personal action which he's bringing, and that's what he's trying to maintain. That's the only action he's got in place prior to the limitation period.
Well, he's trying to recover his own loss. On this hypothesis, he's made his own loss, but he's incurred it, but he can't recover it because it is the, as a matter of law, the company's loss, the estate's loss.
Because the cause of action is in the estate.
And
yes.
the rule says that, the reflective loss rule says he can't sue in his own name, except unless he goes through this new route.
He can't sue in his own
On that
name.
footing, it is necessary for him to proceed,
Well,
only
but
because the action would fail on the first, but you would say perhaps fail on the facts, and well, that's not what the action's about, this action's about.
Exactly, fails on the facts. But it is, however you put it, it is a different claim as amended and is not the same previous claim. The previous claim will fail. It won't be cured purely by the addition of the new party. That doesn't, the new party doesn't establish a duty, for instance, a direct duty. It doesn't, therefore, enable him to maintain that side of the claim. The claim is currently pleaded.
No, but it's necessary in order to maintain a side of the claim. It obviously doesn't help him in relation to the other ingredients of the action.
Yes, but it doesn't necessarily enable him to maintain the original action. It's only maybe one part of it. But that's not the maintenance of the action itself. It doesn't. It's not a cure-all. It's not a panacea, which is exactly what the Law Reform Committee were looking at. The simple fact that the legal owner isn't there.
Well, where do we go from here?
Well, the next thing I have two other points,
Yes.
which I hope I can take. Well, I will have to take fairly shortly, but I don't want to take them to any length. First is the exceptional circumstance. It's this issue, and the second is the Haim and Citibank issue.
Well, let's
Yes.
proceed.
At this point, can I ask you to look at the respondent's case for the first time? It's page 12. Page 12 of the respondent's case, and paragraph 12. And our complaint about the Court of Appeal here is that it didn't identify any error in the judgment at first instance. which would have given rise to a right in the Court of Appeal to substitute its own decision. It's really as simple as that. It's a mechanics. It's not so much the actual decision. In Benedict skeleton argument, he offers you almost a judgment of Paris. He says, well, here's the Lord Justice, here's Miss Justice Morgan, here's Lady Justice Arden. Lady Justice Arden's rather better than Justice Morgan, so let's go with hers. But our objection is that no grounds were identified in the Court of Appeal for overturning the judgment. Now, there was no error of law was suggested because the appropriate legal test was applied. So it may be better if I follow the respondent's case. Lady Justice Arden, with whom Justice Patten agreed, did not identify any error of law or principle in, I've called him Mr. Justice Morgan's decision. The respondents submit the only possible error of law or principle suggested by Lady Justice Arden might be in paragraph 41 of the Court of Appeal judgment, where she there says the danger of setting out a large number of cases is that it may lead to the conclusion that the case under consideration has to be brought within any category of special circumstance already identified. Since that's the only criticism I find, veiled, very heavily veiled, and that's at paragraph 41 in the page 17 of the judgment at divider 5. He says the task of the judge becomes not one of trying to find a precedent, but one of identifying the principle and then applying it to the new circumstance. But the fact is, as Lord Justice Pill himself made clear, the judge made no such error. The judge considered the only circumstance, he considered all the circumstances which could be argued to be special in this case, considered them all, said they're all a different character and contemplated by a different previous authority, but he expressly recognised the list of special circumstances is not closed. Special circumstances have never been exhaustively defined. So he applied the right test that special circumstances or exceptional circumstances were required, and he specifically stated that those have never been exhaustively defined. That's in paragraph 51 of the first instance judgment. But to do full justice, I should show you paragraph 34 as well. In paragraph 34, if we look at page number 29 or 8 of 13, the top of the page, he's looked at Lewin, gone through a number of examples, and then he says in the indented line, special circumstances are not confined to circumstances of these kinds. That's the quote from Lewin. And at paragraph 37, what one gets from the passage in Lewin is there must be special circumstances before derivative action of this kind can be brought. The textbook gives examples from decided cases of special circumstances, but neither the textbook nor the cases attempt to provide an exhaustive definition of special circumstances. He then sets out in paragraph 38 the test laid down in Hyman Citibank. Paragraph 39, Mr. Adams emphasised the words excusable or inexcusable. The decided cases contain a number of examples of inexcusable failure by trustees or personal representatives. However, Lord Templeman's formulation admits the possibility that there can be excusable failure, and so on. So Lord Templeman's own formulation is clearly wider than the preceding authorities. So at a number of points, Justice Morgan focused entirely on the fact that the categories were not closed.
I didn't actually read paragraph 41 in the Court of Appeal as a criticism of Mr. Justice Morgan. It may have been more criticism of the argument that the court had before it, or possibly a reminder that the court shouldn't get trapped into.
No, you're absolutely right. And in fact, I've said, unfortunately, that it may be implicit that it's submitted that it's not that Lady Justice Arden considered the judge of wrongly pleaded. I'm searching for places where she criticises the first instance judge, because she doesn't say he's got the law wrong because he applied the correct law. Court of Appeal, if I D on page 13, Court of Appeal accepted the relevant principle to be applied by the court to beneficiaries of derivative action is that to be found in the High Human City Bank. It's quoted by Lady Justice Arden herself, and that was the principle which Ms. Justice Morgan had applied. Lady Justice Arden, however, simply stated in her judgment, paragraph 45, which seems to be the decisive passage, the fair result in the circumstances would have been to give leave to bring the derivative action. That doesn't say that Ms. Justice Morgan failed to get it right, nor does it even purport to apply the principle which she says should be applied. She doesn't give any reason for that conclusion, doesn't say what exceptional circumstances have been shown, how the judge reached the wrong decision.
What does she mean in 46, Mr. Doom?
46.
She's major point.
Yes, I deal with that in F over the page.
Beg your pardon.
And that's perfectly happy to deal with it, get there more quickly, as it were. F over the page, she is, with respect, wrong, page 46 judgment, to say that the major point in the judge's conclusion was the limitation of advantage claimed by Mark Roberts. That's what she says there. The major part in the conclusion was the limitation of advantage claimed by the claimant. The judge held the potential limitation of advantage was not a special circumstance. So it wasn't a major point. He said that wasn't a special circumstance. But he assumed that there wasn't, that the claimant would be able to get round the limitation point if he could run the derivative action. Lady Justice Arden herself takes the view that he can't get round the limitation point. So that, on her finding, that factor wouldn't even come into the balancing. And the only other circumstance considered by the judge as potentially exceptional, but rejected by him, was the fact that the claimant had public funding. Court Justice Pill agreed with that, and indeed Lady Justice Arden recorded the claimant didn't rely on public funding as justifying the grant of permission to amend. So, again, nothing wrong with the way Ms. Justice Morgan addressed that issue either. So neither of the factors which he thought might be special, but which he ruled out as special, turn out then to be special. She then discusses in paragraphs 42 to 44 the fact that the claimant has got the benefit of public funding, but it's not easy to see why, because she's already said that's accepted not to be relevant and isn't relevant. And it seems, and Justice Pill seems to assume the same thing, it seems that she's considering that to see whether that's the killer blow in my favour, as it were. Not whether it's a special circumstance in the other side's favour, but a killer blow in mine. She seems to decide it isn't.
Is there any provision in the statute which says that the fact of public funding is either relevant or irrelevant in this circumstance?
As I understand it, there is some general provision in the legal aid act to say that the existence of public funding must be ignored, is not to be.
That's what I meant.
Yes, I apologise.
Does that apply here?
I believe it would apply, and I believe that was
Yeah,
what.
do we have to disregard the fact of public funding in deciding whether there are special circumstances?
Yeah,
Is that the effect of the statute?
I think it is good. I believe that was why Mr. Adams made that concession, that they didn't rely on it. Is that right? That's right, yes. I'm grateful for that.
Just comparing paragraph 46 with paragraph 53, it does look as though the CPR rule 19.5 point was the one which both judges regarded as the turning point. I mean, I like you, I'm searching for something that they can say, well, here we have, it's open ground for us. And I suspect that's the point they're taking. Well, this is a new argument because this point is now before us and we can look at the thing afresh.
But if the new point, which allows them to look at it afresh, is that the claim is completely statute barred, then one just knocks it out completely. So that doesn't work, with respect. Lady Justice Arden went on to talk about funding and whether the estate claim could be funded. And she said that if there were other persons who could bring the claim who were not publicly funded, she'd expect the court to consider refusing permission. That was paragraph 43. And here, the revenue are interested, and if a derivative action was made, then the revenue could be joined and could be required to expose themselves to a liability for costs on it, if they wanted to support it. They could have been asked while the limitation period was still current whether they wanted to fund it. The revenue do fund claims, causes of action which would recover sums of money which would satisfy their claims of tax. I've been instructed by them myself in those that sort of circumstances. So she indicates when she might expect the court to consider refusing permission, which seems to potentially apply to these facts. But on any footing, a factor which might lead the court to consider refusing permission isn't itself a special circumstance. And then when she concludes her, paragraph 45 appear to be the conclusions, but starts with saying that Mr. Johnson submits special circumstances are not shown, and then I submit that the claimant could have made his application to amend some time ago. My judgment, in the absence of prejudice, that's not a good objection. I was making, I'm afraid, a few jury points at that point, and they weren't working. But she doesn't actually indicate there what special circumstance she is relying on. She says, she bears in mind in our favour that we wrote them a long letter at the early stage explaining what the problems were before the limitation period had expired, and so on gives the history. But notwithstanding that, which she says the fair result in the circumstances of the case would have been to give permission to amend the derivative claim. The solicitor service take an application to strike the personal claim out. Not clear why one would strike out a personal claim when a derivative claim was in place, because its personal claim becomes then unimportant. But there's no special circumstance indicated. And she says in paragraph 45 that as things stand, the court is not in a position to say the claim of the estate has no value. But as Lord Justice Pill said, that the existence of even an arguable claim is not a special circumstance. It would be a special circumstance, I accept, if there was an open and shut claim, and in one of the reported cases there pretty much was. There was money in court, and all you had to do was make the application. You get the money out because you could show a clear, equitable or legal title to it. But if it's an open and shut case, maybe that would be a special circumstance. But the fact that it is just a case, which it is not said has any better prospect of success than a failure, or that can't say it's got any actual value, is not itself a special circumstance at all, and that must be clear. And in paragraph 42, and because this may be where the real difference of view occurred. Lady Justice Arden said she regards the facts as a derivative claim will enable an asset that could not otherwise be realised, will be a very powerful consideration. She doesn't say it would be a special or exceptional circumstance. And we submit that the judge at first instance was quite right to reject that as a special circumstance for the reason given by Mrs. Goff in Refield, that can't be a special circumstance, because if it were abrogate the rule, special circumstances must be shown. You're only there because the only way of recovering it is by the proposed derivative action. If there was any other method, that would be...
Why isn't that a special circumstance? Why isn't that a special circumstance?
Well, because...
Obviously, one would hope in the vast majority of cases the trustees would have some monies and be able to go ahead and get in the trust monies. That's what trustees are for. But why isn't it a special circumstance? They simply can't do that. Here they couldn't do it. The previous personal representative included the beneficiary, didn't it, Mr. whatever it was called?
Well, up to that point, he did, but then there was a previous representative who was there.
So the whole history of things being very unsatisfactory from the beneficiary's point of view. So why isn't all that a special circumstance?
Well, because if you can look at the history of it...
And if you're allowed to take account of what's fair and just in all circumstances, which is perhaps part of special circumstances, I don't know. But,
if you can look at the history of it, there were a matter of a year or so, 2 years, when the current administrator was already in place. The brother had been replaced, so they could have pursued it at that stage if they wanted to. The fact that they didn't is why it can now only be recovered, because there's on foot the personal action. It's an odd circumstance, but the fact that this is the only way recovery can be made is not a special circumstance, because it will occur in every case that a derivative claim is being sought. And that's what Mr. Justice Goff said.
Because if the estate's got some money, or is able to obtain some money, then that won't be the case, because the estate will be able to proceed.
Well, the estate might not want to proceed. If you've got money...
Well, it might not want to.
But if the action is not run, then the asset can't be brought back in, whether the estate's got money or not. So that factor is always going to be present in any case of this kind. It's not a special circumstance. The sort of special circumstances typically, I know, one gives examples. One looks like one's giving limited categories you can't appear outside of. But the very reason Mr. Justice Goff it is the sine qua non. It's not the special circumstance. It is the very condition that one would expect before an application is ever made, and that in itself cannot be a special circumstance. But essentially, the process by which, as I understand it, and I'm not sure I do understand it very well, in order to overturn the decision of the first instance judge, you have to show he's wrong. And in order to do that, you have to show either he got the law wrong, that didn't happen here, he got the facts wrong in some way that the court is prepared to overturn, that doesn't happen here either. What happens here is he's applied a relatively general test of special circumstances. He's balanced all the factors. He's taken everything into account. He's exercised his judgment on the basis of the previous decisions, authorities, and how he sees them all. And as I understand it, the Court of Appeal is normally very reluctant to interfere with a decision of that kind. Might take the view that you might have come to a different decision, but that isn't enough.
Mr. Justice Morgan seems to lay some emphasis on the point in points 5, 6, 7 in paragraph 50, that he didn't obtain an assignment of the right of action. Is that a relevant factor?
Well, what he's done is he's looked at all the factors, really everything that I think Mr. Adams and I said about the case. He's lined them all up and then has gone through them to see if any of them are special. He hasn't used them to rule it out or something. He's taken it into account, are these special circumstances? And yes.
Well, these must be indications of the reason why the circumstances aren't special.
Yes.
He must be saying because he didn't apply himself to have an assignment of the right of action. Mm-hmm. That somehow or other, it seems to suggest that for that reason, that leads him to think, well, this isn't this kind of special circumstance where you should allow him to take the action in the name of the estate. Because he could have done it, it seems to be said, by obtaining an assignment of the right of action, which he didn't do.
Yes, and he didn't. So that is not But the fact that he didn't do it is not a special circumstance which entitles him to...
What is it? What is it, Mr. Woodall?
But imagine the relevant circumstances. These are all the circumstances in the action which have emerged in the course of the argument before him as being submitted by one party or another to have some bearing on the history, the background, and so on.
Yes, as I understand it, paragraph 51 looks at the list.
Yes.
And then is saying, well, let's take, for example, the penultimate sentence or third last sentence, paragraphs 17 and 18 are not special circumstances which would justify bringing of the claim. So, I mean, he's listing these as factors, I suppose.
And if I looked at the first two lines, even, my lord, too,
yes.
In the list of circumstances in paragraph 50 above, the circumstances listed in subparagraphs 1 to 16 do not, in my judgment, amount to special circumstances justifying a derivative action within the authorities I've referred to.
Yeah.
So he's looked there to see if there's anything in there which will give him assistance.
So he's left with 17 and 18 and he...
Yeah, he's left with 17 and 18 as matters which have some kind of flavour,
Yes.
considers them and rejects them.
I mean, are they just, I mean, are 1 to 16 simply irrelevant, and otherwise might well not have been written at all?
Yes.
It seems very odd to me, speaking entirely for myself, it seems to be a very odd way of doing it. You have a list of factors. You don't say, well, the thing to do now is to stand back and say whether, having regard to all those factors, there are special circumstances. Instead of doing that, you look at each one, and if it's a particular one isn't by itself a special circumstance, you cross it out. And so you then disregard all of those, except ones that, and then you're left with 2. Well, I wonder if that is right. To my mind, if there is an error of principle, that is it. Because that's just not simply the way one ought to be focused on. You should look at the whole case, look at its key factors, and obviously the key factors here are the estate didn't proceed, it couldn't proceed because it didn't have any money, he could proceed. We assume for this purpose that the claim is arguable, justice requires he should be allowed to proceed, and those are quite sufficient special circumstances. What's wrong with that? After all, these are supposed to be courts of justice.
But these factors do in a way fit together, don't they? Because coming back to that he didn't procure by way of an assignment. Well, Mr. Sainter, if he'd been asked to make an assignment, would have no doubt had to take legal advice. And he would have been advised he couldn't simply pass it over for nothing. He would have said you can assign it only for value.
Yes.
And so inevitably the answer would be that it was to be the fruits or 95% of the net fruits of the action. And so immediately you're into quite a familiar situation of an ex-bankrupt taking an assignment from his trustee in bankruptcy of a right of action that he passionately wishes to pursue and the trustee doesn't. Or similar situations with a principal shareholder in a bank, in a company that's gone into insolvency. But if those factors had been investigated, and it doesn't seem they are, could Mr. Sainter, one asks oneself, have made an assignment of that sort without at the same time making himself potentially liable for the cost of the action? And so it's not that simple, is it? They all do. These factors fit in with each other.
Well, they do. In my submission, if he made that assignment, well, then there's learning on in bankruptcy on whether that exposes some of the assignor to any liability.
Yeah, I express no view about it at all, but it's not completely inconceivable that it might.
But it still seems that there were methods where an action could have been simply and easily maintained within the limitation period. And that may well therefore be a significant question in whether to consider, in the absence of even the estate, whether exceptional circumstances have been shown. And to be fair to Mr.
We've reached 12 o'clock and we're obviously not going to finish in a few minutes. So I'm afraid we better break off here and come back at 2 o'clock. But there seems to be ample time to finish this afternoon, I think, doesn't there? Good, well, see you at 2 o'clock.